This is David Demergent for Legal Update number 3. I've been a practicing attorney for over 30 years throughout the United States, representing police agencies, officers, deputy sheriffs, federal agents, involving all different types of matters involving officers and anything that impacts the law enforcement community. I decided to do this legal update. Today we're going to be covering a matter that pertains to a criminal matter here in the Los Angeles area. Most importantly, before I proceed, as the disclaimer said in the beginning, please, I offered you this particular update for information purposes only. Seeking legal advice, please go to competent counsel in your jurisdiction. The laws are vastly different throughout the country and even within the state. So it's important that you seek counsel from an attorney that is in your jurisdiction, particularly for any matter involving the scope of your employment if you're in law enforcement. Let's now turn to what happened here most recently here in Los Angeles. On March 29, 2023, the Los Angeles County District Attorney's Office filed criminal charges against 7 California Highway Patrol officers, 1 sergeant and 6 patrol officers, and a registered nurse, and charged them with the death of a suspect. The 7 officers were charged with 1 count of involuntary manslaughter and 1 count of assault by an officer. The nurse was also charged with involuntary manslaughter. This involved an event that occurred back in March of 2020. The suspect was traveling northbound on the 5 at night when the CHP officers pulled over the individual, suspecting that he was under the influence of alcohol and or a controlled substance. He was taken to the Altadena CHP station. Altadena is in the northern part of Los Angeles County, where he declined to have a blood test. Outright refused. It went back and forth. You'll see it on a YouTube video where it goes back and forth, where he says he's going to do it, doesn't do it, adamantly says he's not going to do it. They try to convince him, and then he says it goes on back and forth, back and forth. And then around the 18-minute video, the recording by the CHP sergeant shows the officers warning the suspect that if he doesn't comply, quote, he is going to be put face down on the mat and we're going to keep on going. There was an actual gym mat that was laid out in the parking lot, so if force was applied in which they had to secure him on the ground, they didn't want to secure him on the pavement, they actually had a mat. And then they secured him because they were able to draw the blood then accordingly. Prior to doing that, the CHP officers contacted through the use of a telephone a judge that was on call with Los Angeles County and sought a search warrant. The search warrant was authorized by the judge, thus ordering the officers to do the blood draw. Accordingly, they did. At one point, while this is going on, Mr. Bronski says he's going to do it. They go hands-on. They draw the blood. He says he can't breathe. As the blood draw continues, the suspect became unresponsive. He was kept face down for approximately 6 more minutes. Approximately 10 minutes after he became unresponsive, the officers attempted CPR, but at that point, he never regained consciousness and later was pronounced dead. The autopsy was done by the Los Angeles County Coroner's Office. The cause of death, according to the coroner, was acute methamphetamine overdose and caused by the application of force by the officers. So methamphetamine was in the system, basically causing him to then, according to the coroner, was the cause of his death. Now, most importantly, the information I have is the same information you have. This is limited. I only have public sources. This is an ongoing criminal investigation, both by the CHP is doing an internal investigation. The district attorney has their investigations. They're doing their investigations. The attorneys are involved, so there's going to be criminal defense attorneys with their investigators. A lot of that information is not available to me or to you until this matter is resolved. So I warn you that I'm only taking bits and pieces of what I see and telling you based upon my training experience of 30 years, this is what I suspect, this is what I see. There might be a totally different spin on it because there's, like I said, there's a lot going on here that we're not accessible to until this matter is resolved. Now, let's take a step back. How did we get here in the first place? Let's remember the problem of DUI, alcohol, and or drugs. In 2009 to 2018, almost 9,288 individuals were killed in California involving alcohol-impaired drivers. Per year, about 10,000 fatalities nationwide are caused by alcohol-impaired drivers. That is the primary concern of the CHP officers when they're out there at night. They're looking for impaired drivers. The impaired driver, whether it's alcohol, drugs, or both, a combination of both, unfortunately, they still get in the vehicles and innocent people die or are seriously hurt because of an impaired driver's operation of their vehicle. So the primary concern, one of the primary concerns of CHP is to find these types of drivers before the collision occurs. I'm assuming that's what we have here. The officer traveling northbound on the 5, a major thoroughfare that goes to the state of California, all the way north, all the way south, all the way north. They observed his operation of the vehicle. At one point, they made a determination that he is under the influence. I assume they pulled him over and gave him field sobriety. I assume there might have been a preliminary alcohol screening device. Maybe it was used, maybe it wasn't used. And at that point, the officers determined that this individual is under the influence of alcohol and or a controlled substance. Now, the legal authority to draw blood is actually, this is old case law. The case that originally started with the use of drawing blood is a case that came out of the U.S. Supreme Court. The case was actually a 1966 case. And by the way, in the state of California, if you refuse to take your choice of either breath or blood test to determine your blood alcohol content, your refusal here in the state of California means that if you're convicted of it, a 1-year suspension of your driver's license and possibly 2 days in jail. That's if you're convicted. So you're not given a choice. The choice is very limited. You can do it, but you're going to lose your license and face jail time. If you do it, you're supposed to. It's the consent that you have or the privilege that you have to drive here in the state of California. Now, the actual drawing of blood in which the sample, again, I would say when it comes to prosecuting these cases, one of the best pieces of evidence is blood. The blood will show us exactly what's in the person's system if it's drawn correctly and it's analyzed correctly. With that, you get an entire panel of what's going on in the person's system. The case that started this, or the one that has addressed this, is a 1966 case of Schmerber versus California. Supreme Court held that a warrantless blood draw after a DUI arrest was allowed in that case. In that case, we have an individual gets into a collision, gets taken to the hospital, refused to have his blood drawn, and the officer orders the hospital technician to draw the blood. They do draw the blood. Now, that case went all the way up to the U.S. Supreme Court. The concern is that the longer you wait to go get a search warrant, because again, this is going into somebody's body, there's an intrusion here, that the blood alcohol that's in the body will begin to dissipate, because why? The body's beginning to metabolize it. And that's what's the exigency of the circumstance, thus justifying the warrantless intrusion into the body. Schmerber was in 1966 says, all right, we have to concern ourselves with the fact that the longer we wait here, the destruction of evidence, the blood alcohol. It's slowly going down as the person as time goes on, the body's metabolizing it. So in Schmerber, okay, forcible blood draw. Now the case or the theme or the issue gets revisited in 2013 in Missouri versus McNeely. The court then sets out to answer the question of whether the mere fact that alcohol in a DUI suspect's blood is dissipating with each passing minute constitutes an exigent circumstance, thus permitting the law enforcement to draw blood from the suspect against his or her will without a warrant. Again, without a warrant, whether or not the exigency that the blood alcohol is going down as time weighs, can we do it without a warrant? The Fourth Amendment to the U.S. Constitution provides the right of the people to be secure in their person, houses, papers, and effects against unreasonable searches and seizures. Shall not be violated without a warrant. A warrantless search by law enforcement is, however, justified if it meets one of the narrow exceptions to the warrant requirement. This narrow exception that we're talking about is exigent circumstance, the blood alcohol levels going down. In some circumstances, the emergency giving rise to the exception to the warrant requires can be based on the imminent destruction of evidence. That's what we're talking about here. So did the McNeely court how did it feel without a warrant? It's interesting. Now, because of the advancement of technology, the McNeely court declined to adopt the rule that the evaporation of alcohol in a DUI suspect's body as time passes and it becomes metabolized constitutes a per se exigent circumstance justifying a warrantless blood draw against the suspect's will. The court held that those cases where police officers can reasonably obtain a warrant before a blood sample can be drawn without significantly undermining the efficacy of the search. The Fourth Amendment demands that they do so. There's the answer. Due to technology now, all you do is pick up the phone. They have judges on call, which they do in LA County. In most counties or busy counties or large counties, they do have judges on call 24/7. You get telephonic permission, a warrant, and that's what happened in the CHP matter. Before these officers decided to go hands-on with the suspect, they got onto the call, called the LA Superior Court judge that was on call that night, gave him the set of facts of what happened, put the officer under oath, and then the order came. The judge then ordered them to take that blood sample. Of course, the blood sample had to be taken in certain protocol. You can't just, grab somebody, smash them down to the ground, beat them up, and then take the blood. That's not what happened here. So it has to be taken within certain parameters that are reasonable. Now, with that said, understanding the CHC's officer's mandate is to look for people that are under the influence. They go and get their search warrant. They then bring them to the station, and they get a licensed professional, a nurse there, to assist in this process. So somebody who's able to oversee the proper drawing of the blood and also oversee the welfare of the individual. I put that in because that's something to think about. I believe that the officers, pursuant to their policy, had done everything. But again, I give the caveat, I do not see the case file. I'm only going on public information. So that could all change because something else that the DA knows that I don't know, which is important to give him leeway as to he's prosecuting the case. Now, the count that's been charged, a serious count, is the Penal Code Section 192B, involuntary manslaughter. What is involuntary manslaughter? In order to convict these officers, the prosecutor must prove the following beyond a reasonable doubt. The officer committed a crime, or the officer committed a lawful act in an unlawful manner, and committed the crime or act with criminal negligence. That's key, criminal negligence. And the criminal negligence was the approximate cause of the death of the person. There's a lot said there. Criminal negligence is different from what you hear in civil negligence, and whatever the act was has to be the approximate cause of the death of the individual. We have an autopsy report that says that methamphetamine was basically, or a primary cause here, brought on with the application of force by the officer, but the methamphetamine could be argued that that was the proximate cause. Again, I couch it with the fact that I'm going off of limited information. What's the penalties that the officers face if found convicted of involuntary manslaughter? They're looking at 4 years in prison and a fine of up to $10,000. The key to understand here, is criminal negligence. You don't get that confused with ordinary negligence. You see ordinary negligence in civil actions, personal injury matters, traffic collisions, slip and falls. That is ordinary negligence. Criminal negligence is different. Criminal negligence is he or she acts in a reckless way that creates a high risk of death or great bodily injury, and a reasonable person would have known that acting in that way would create such a risk. He or she recklessly created a high risk of death or great bodily injury, and a reasonable person would have known that these acts would create such a risk. It is important to note criminal negligence involves knowledge of a danger and more than a mistake or excusable accident. That is key. That is key here. Just understand, more than a mistake or excusable accident. So more than a mistake requires inattention, or again, it's not a mistake in judgment, no inattention, or simple carelessness. It only pertains to conduct that is outrageous and reckless, and shows a clear departure from how an ordinary person would act in a similar scenario. That's key. Again, the level of negligence we're talking about is extremely high. It shows that it's a clear departure from what an ordinary person will do. Outrageous and reckless conduct. This is going to be where maybe they focus on this in a trial if it does go to trial. The officer, they must show that the officer have knowledge of a danger. To have criminal negligence, a person must know that an act created a risk to a victim. In particular, a defendant must have knowledge that either his acts created a risk for the victim, or a reasonable person in a similar situation would have appreciated or foreseen this risk. That's another point that has to be explored if they go to trial. The other fact that the other charge that was put in is also under a color of authority. In California, it's Penal Code Section 149 PC, makes it a misdemeanor in California when a public officer who under color of authority without lawful necessity assaults or beats any person. A conviction of punishable up to 1 year in jail, and fines are up to $10,000. Basically, the police are not given a license to physically touch or hurt anyone unless they have lawful necessity. That would have to be explored in trial too. The application of force they were using was pursuant to the court order in order to take the blood to assist in the prosecution of an individual who was under the influence of something at the time. The question was in the manner in which it was taken. And I think a key part of that was also the presence of a medical professional assisting in this process. Overall, this is a tragedy. An individual has died. These officers, this nurse, are now facing some very serious criminal charges. This is an open matter. I will keep you posted regarding it. In the meantime, I want you to understand to be safe, be aware of what's going on, particularly with the fact of traveling your roads nowadays. It is very dangerous, as we see. There's a number of incidents involving a lot of fatalities now, more so than last year. Keep that in mind, that if you're doing enforcement in this area, it's important that you understand that the courts are looking at, this, in this case, the evidence gathering. And in many cases, maybe in a more medically permissible environment might be more appropriate. Again, that's my opinion, not really making any relation to this case, but just giving you a heads up on that. In the meantime, this is David Demergent for Legal Update. I'll see you next time.